In this final lesson looking at the concept of equity, what we're going to do in this video is specifically talk about the maxims of equity. Now, this isn't going to be something that is going to take much time, essentially, because what we're going to do is list the maxims of equity. I might pick out and highlight a few of the interesting ones, but for the most part, we're not going to go into an advanced detailed examination of each of them because there's not really necessity to do so. When a maxim of equity comes up in the subsequent lessons on the law of trusts, we will highlight them and we will talk about them in relation to the particular context of trusts that we are examining. Remember, this is a series of lessons on the law of trusts, not specifically on the law of equity. And so as a result of which, in looking at equity, it's important to be able to provide an introductory examination of this subject, but then to now move on to thinking about the concept of the trust in more detail. So we know already that the Court of Chancery developed over many centuries a distinct jurisdictional element of the law that we now call equity. And one of the guiding principles behind this idea of having this jurisdiction of equity was the establishment of a number of maxims, which were designed to offer some overarching guidance to judges, or at least to members of the Court of Chancery, when it comes to the administration of equitable jurisdiction. So these aren't necessarily strict adhered to rules, but they are characteristics of equity, if you will. They are the things that we can attribute to the concept of equity in our understanding of the subject. And so we can distill these into a series of maxims, which are then still applied in law to this day. And as an overview, the maxims of equity are as follows, and we'll talk about some of them in a bit more detail, but in their generality, we have a few. So we have, for example, the maxim that equity will not suffer a wrong to be without a remedy. Equity is equality. Delay defeats equity. He who seeks equity must do equity. He who comes to equity must do so with clean hands. Equity acts in personam. Equity will not perfect an imperfect gift. Equity follows the law. Equity regards that done which that ought to be done. Where the equities are equal, first in time prevails. There are others, of course, there are others that exist, and we will come and go when we look at the different kinds of maxims that exist. We would pick out a few of these ones as well. Some of them are quite easy to understand, really. So, for example, he who seeks equity must do equity simply means if you are looking for an equitable remedy, you must have acted equitably yourself, okay? But we will get to some in more detail. Let's think about this, the first one then. The idea that equity follows the law. What does this actually mean? Well, it simply tells us that unless there is a reason not to do so, equity will now follow the rules of the common law. So if a common law decision exists and is applied in a correct way, there must be a standard by which equity should contradict that a particular common law rule. So it means that unless there is some reason to abandon a particular common law rule, equity will not contradict that said common law rule. Instead, it must essentially try to harmonize itself with the common law. So one of the things that is clearly a problem when we talk about the distinction between law and equity as separate jurisdictions is the idea that the two jurisdictions will clash. And we had conversations about this when we were looking at the history of equity, when we were looking at various clashes that existed between the Chancellor and the and Lord Justices, like Lord Justice Coke having some problems with the Chancellor in terms of determining the correct remedy and outcome of a particular case through the lens of either the common law or through the lens of equity. And so today, one of the maxims of equity tells us that instead of trying to act as a force against the common law, equity should harmonize itself with the common law, such that rather than trying to step in and contradict the common law, equity acts in a way which essentially smooths some of the rough edges of the common law jurisdiction. The second maxim, he who seeks equity must do equity. We mentioned this already, but simply an individual who is looking to seek some kind of relief out of equity, they themselves must act in a way which is fair towards the opposing party. They must be equitable in themselves in order to actually be able to seek some kind of relief. Those who seek equity must do equity seems to make sense. It doesn't seem to be much. It doesn't seem to be quite fair, shall we say, that if somebody seeks to have an equitable remedy implemented in their favor, they should be acting in a way that is equitable themselves, because otherwise then that is a particularly unjust application of the principles of equity. A good example of this is illustrated in the case of Chapel and Times newspapers, where it was illustrated that if an individual seeks to get an injunction for the specific performance of a contractual obligation, that individual themselves must also be willing to fulfill their own contractual obligations, because otherwise they would be achieving an unjust settlement in that particular example. Another important maxim is this idea of equity essentially being something which acts temporally. So where the equities are equal, the first in time prevails. Essentially, it means that where there are two claims that are equitable claims that both have equal merit in their own right, in those circumstances, the individual or the organization or whoever who made that claim first will be the one that has priority over the other. Okay, simple as that. So where there is a clash in equitable claims, where equities are equal, the thing that delineates them is the time at which the claims were implemented or levied against the other. And so the result of which is that equity acts temporally. It acts and favors those who enter a claim first. Another very important maxim is the idea that equity will act in personam. The point behind this is to try and look at how equity applies to the individual specificities of each and every case. So we will see that in the types of remedies which are issued in equity, the idea is that we are not applying broad standards across consistencies of cases. We are applying specific minutiae against individuals in individual cases. We are looking at the facts of each of the cases themselves. We are acting in personam. And so a result of which is, if we look at some of the remedies, things like search orders or injunctions, they are very personal in terms of their application and specificities to individual cases.